and welcome. You're watching We the People. I'm Rishika Barua. A married woman, 26-week pregnant, has approached the Supreme Court seeking to terminate her pregnancy, citing the inability to take care of the child due to postpartum depression and other health issues. The petitioner, like I said, is a 27-year-old already mother of two. She explicitly told the Supreme Court of India that she is not in a position to take care of a third child while she is still breastfeeding her second. In fact, it was because she was breastfeeding that she didn't realize she was pregnant. On the 9th of October, the Supreme Court allowed the abortion. A day later, the government filed an application to recall the order, saying that the fetus is viable and has a heartbeat. 2 days later, brandishing this very report from the All India Institute of Medical Sciences Medical Board, the court gave a split verdict. They couldn't agree on whether a fetal heartbeat should be stopped or not. So the matter was then directed to a larger bench headed by the Chief Justice of India, which observed that the highest court of the land cannot overlook the rights of an unborn child. 7 days later, the Supreme Court rejected the abortion plea. This has once again reignited a pro-life versus pro-choice debate in the country. But before we get into the larger issue, let's look at the broad contours of what is the abortion law in India. Abortion is a criminal offence in India under Section 312 of the IPC. So a woman and her doctor can both potentially be sent to prison for carrying out an abortion. Then came the Medical Termination of Pregnancy Act in 1971, which was later amended in 2002 and 2021, which essentially allows for abortions within gestational limits and with certain conditions. So pregnancy within 20 weeks is permitted with an opinion of one medical practitioner. The termination of a pregnancy between 20 to 24 weeks is allowed only under special circumstances with the medical opinion of two medical practitioners. And for an abortion at 25 weeks or beyond, a medical board is constituted and two conditions need to be met. One is grave fetal abnormality or threat to the life of the woman. In this case that we're talking about, neither of those two conditions, according to the court, were met, and hence the court did not allow the termination of pregnancy at 26 weeks, citing no threat to the mother and no threat to the child. So while in letter we have a progressive law, in spirit, the United Nations data shows that 8 women in India die every day due to unsafe abortions. The United Nations data says that an astounding 67% of abortions in India are illegal and therefore unsafe. So while abortion continues to be an exception and not the rule, women in India are either at the mercy of doctors or at the mercy of courts to terminate pregnancy. Caught between the right of the woman and the unborn child, tonight on the show we ask, whose heartbeat is it anyway? Joining us is a very esteemed panel in the studio. We have Mimamsa Singh Tanwar. She's a clinical psychologist associated with the Fortis Group of Hospitals. We have with us Dr. Amit Mishra. He's an advocate of the Supreme Court who moved the Supreme Court last year in the case of an unmarried woman seeking abortion, which led to a historic verdict in the Supreme Court last year. Thank you very much for being with us. We also have Dr. Nikhil Dattar, a senior gynecologist based in Mumbai. He's also a lawyer, and it is his fight for abortion rights that actually paved the way for amendments to the Medical Termination of Pregnancy Act very recently. We have Professor Deepika Jain. She's a professor of law, Center for Justice, Law and Society at the Jindal Global Law School. And we also have Dr. Suchitra Dalvi. She's a consultant gynecologist and a coordinator for Asia Safe Abortion Partnerships. Thank you all very much for being with us on We the People. I want to begin, Dr. Amit, by asking you, it was your case in the Supreme Court last year that actually led to a very historic verdict in terms of widening the definition and scope of abortion in India. Do you look at this verdict, this recent verdict of the Supreme Court in 2023, therefore as a setback?
Yeah, thank you, ma'am. When we compare with both the cases, last year judgment and this one judgment, then last year judgment was very progressive, and that was a landmark in itself also, which gave a reproductive choice, bodily integrity to the mother. And there was no difference between this case and the previous case. The difference is only one, that in the previous one, the lady was unmarried. And there was no threat to mother, there was no threat to child also. And in this case also, the facts are same. Difference is only this, I am married. In this case, there is no threat to as such mother and there is no as such threat to fetus.
Right.
So difference is that in the previous one I was unmarried, in this one I was married. So why the difference between both of them? There was I was 25 weeks, here I was 26 weeks. So the question of fetal viability, I think erroneous in this.
Okay.
Already there are landmark cases before this also where 27 weeks, 28 weeks and 30 weeks also, 33 weeks abortions are granted by the Supreme Court and various high courts in India. And there, in all those cases, there is no danger to fetus or mother. Even after that, only on the ground of mental health, that there is a grave injury to the mother, only on that ground, the abortions are allowed. But I don't understand why in this case, being married, I was denied. So according to me, the justice was not done in this case.
Right. The Supreme Court, just for the benefit of our viewers, last year it delivered a very historic verdict, and Dr. Amit here was the petitioner in the case, where they'd expanded the scope of abortions in the country. They'd actually allowed for abortions up to 24 weeks with, of course, conditions. Abortions were also extended, to unmarried women. So it was a very historic verdict in a certain sense. But from what we understand, what's happened last year versus what's happened now is that there are very different interpretations of the law. So there are very different things that the court is saying in different cases. And I want to bring in Professor Deepika Jain into the conversation here, because Professor Jain, do you think this is very problematic because you have different courts saying different things in different cases? I mean, what kind of precedence is this setting? This is leading to utter confusion on the ground, isn't it?
Absolutely. This is really about a classic case of legal indeterminacy, where different judgments with similar circumstances are having different verdicts. And the reason is very clear. It's because the inconsistency around the abortion jurisprudence comes from a clear distinction between what a good abortion is and what a bad abortion is. So, for example, what Dr. Amit was saying, if it's a married woman, then it's a bad abortion. But if it's not a married woman, it's a young woman who's unmarried and has suffered sexual assault, then it is a good abortion, right? So there is that kind of distinction, and that's also because this perception is there both within the doctors, healthcare providers, and the judges. Now, this is not just how the adjudication happens, it's also the legal design of the law, which is the problem, where there is no centrality to the autonomy of the woman or the pregnant person, and because of which there is too much flip-flop that happens. So, for example, in this case itself, if you see, the first time the two bench judges allowed termination, then one of them felt, no, this is very heavy on my conscience. And then it went to the three judges, and they did flip-flop within their decisions through two medical board reports. So what is this telling us? That a woman's autonomy, while held as absolute last year in 2022 judgment, it's an absolute fundamental right, according to the judgment, has now been negotiated. And the negotiation is happening on biases, which is really problematic.
Right. And like I said, what is the kind of precedences set for lower courts across the country? And let's just also, tell our viewers over here that there are over 1,000 women that actually file abortion cases in courts. These are the number of fresh cases that are filed every year in our courts. And this is again a small percentage of women who have access to courts. So, what's really happening on the ground as far as abortions is concerned, I think is available in that statistic where we learn from the United Nations data that there are 8 women losing their lives to unsafe abortions every year in the country. And I want to bring in Dr. Nikhil Dattar, because he's a senior gynecologist, but he's also somebody, who's been an architect in a certain sense of the amendments to the Medical Termination of Pregnancy Act. Dr. Dattar, tell us what's really happening on the ground. I mean, there are progressive versus regressive things that are being said in court, and all of that is one aspect. The letter of what is being said is one aspect, but in spirit, what is happening on the ground? Tell us.
So as you are aware of the fact that there was an amendment to the Medical Termination of Pregnancy Act, and now we have a new act which has kind of liberalized the terminations of pregnancy from 20 weeks to 24 weeks and even beyond 24 weeks. So definitely there is an improvement, but improvement is not enough actually, because there are still a lot of fallacies that I see in the amended law, and that's precisely why, and unfortunately, I have had to once again challenge the Termination of Pregnancy Amendment Act in the Supreme Court, citing the difficulties and the problems. And one of the biggest problems that I see over there, of course, one of it has already been solved by Advocate Amit last year. That is about this discrepancy caused because of the marital status.
Yes.
Now, the truth of the fact is that although there is a judgment which is delivered that married and unmarried women cannot be differentiated on the basis of their marital status, in terms of providing the termination of pregnancy, the ground level situation is that today, if there is a woman who is unmarried, not a rape survivor, not having an abnormality in the fetus, she goes to a hospital, the doctors in the hospital will say that, look, I have to follow the rules under the law. The rules under the law have not been changed so far. Judgments and all that, we have no understanding of all that. We can't keep up with judgments and
So
all
one
those
minute,
kind
can I
of-
just
That's
interrupt
not
you
our
there and
job.
understand, Dr. Mishra, you're saying that there have been judgments of the Supreme Court and other courts, but the rules on the ground has not been changed. So governments have not
Yes.
been notified. So doctors are still reluctant to carry out abortions. Is that what you're saying?
Yes, correct.
Okay, go ahead.
So what is happening is that although you have recognized all these things there in the code and in print, but on ground reality there is no change. Now, second big problem that I see with the amendments is that if you see even a minor girl who is a rape survivor, imagine a girl who is 12 years and 13 years and she is found to be pregnant, and it's very common that very young girls, I mean, they just by virtue of being too young, by the time people notice that they are pregnant, they are many a times beyond 24 weeks. And in spite of that fact that she is a young girl, the amended Termination of Pregnancy Act also does not still allow a termination of pregnancy
Right.
to her. Now,
Because the
contrary to
condition,
number of-
because the condition beyond 24 weeks is
Correct.
only two: threat to life of child or threat to life of mother.
Correct. And
Right.
the third big problem that I see in the amendments is that they have come up with this medical board. And if you look at the whole architecture of the medical board, the way the medical boards have been made, it's very funny actually, because the medical board is supposed to have one pediatrician, one radiologist, and one gynecologist minimally on the board. While on the other hand, your medical termination of pregnancy 1971 Act says, and the rules thereunder say, that the person who can terminate the pregnancy has to not be a doctor only, but has to have a certain degree of experience / qualification
Right.
in doing medical termination of pregnancies per se. So typically a gynecologist. So in short, if at all on your board only one gynecologist is there and other non-gynecologists are there who have got no qualification / experience in doing termination of pregnancy,
Right.
I mean, how shoddily or how effectively is that board going to function when people sitting on the board don't have the required qualifications or experience? So
You've raised-
in short, it's kind of a sham, I would say, that these boards may not effectively work and provide
Right.
justice to a woman just by virtue of making it in a very shoddy manner.
You've raised several very important points, and I think the moot point here, the larger question it all comes back to is, whether we just need to decriminalize abortions in India, and whether that's really going to be, the end game solution to a lot of problems that several panelists have raised. But I want to also, delve into the other side of the debate. Dr. Suchitra, if I can bring you into the conversation here, we have very stringent laws in place because of the threat of feticide. Even in this particular case in the Supreme Court, the petitioners who argued against the abortion said that, killing or terminating a viable pregnancy when there's no threat to the mother or to the child amounts to feticide. But feticide has also been a very real problem, continues to be a very real problem. Do you think there is some level of confusion when it comes to abortions versus the threat of feticide?
Thank you for asking that question. It's actually, requires much longer and deeper conversation. But just to put it very briefly, I think the conversation really needs to be central to the person who's pregnant and what it means for them to not have to continue an unwanted pregnancy. I think all other questions, including the last 2 decades conversation around feticide, specifically female feticide, needs to really center around the conversation of gender discrimination and the status of women in our society. And I think this is what is coming up even in this judgment, is that the person who's pregnant, the woman herself, her autonomy and agency were not given priority. And, by bringing in the fetus into the conversation in the first place, I think is what has muddied the waters. Going back to what the others have said also, does a woman as a citizen of this country have the right to decide what to do with her body or not? And I think that really is the central question. And it's been addressed by other courts earlier. So the Mumbai High Court in a judgment couple of years ago said very clearly, and this was with regards to a woman who was in prison. And they said her external circumstances don't matter. If she's pregnant and doesn't want to continue it, she has every right to not continue the pregnancy.
Right.
And in the right to privacy judgment that was passed, when the Aadhaar conversation was happening, also a statement was made, not as part of the judgment, but another statement saying the right to privacy also includes the woman's right to take decisions about her own body in a private sphere.
Right.
Not having it opened up to a debate and, having to go to court. So I think this woman particularly was failed at many levels, even before she reached the Supreme Court,
right,
in terms of being able to have ownership over her own body.
But this is the larger question that I asked, right? That there are so many different interpretations, so many different cases where different judgments have been delivered circumstantially, that it's very hard to actually understand what really, is the basis on which courts are taking these decisions. But, I want to also address the elephant in the room. Mimamsa is with us in the studios as well. Thank you very much for being with us. The larger question here, and, just taking off from what Dr. Suchitra Dalvi said as well about the moot point, does a woman really have the right over her own body? And are we completely ignoring the fact that, when you talk about the viability of the fetus and you talk about no threat to the mother, which were the two reasons that were cited in this particular judgment, are we completely ignoring the psychological factor, of this debate?
Oh, absolutely. I think we are completely denying and not acknowledging the mental health aspect over here, because if the woman is struggling with peripartum depression, there are obviously certain signs and symptoms that is going to impact her ability in child rearing, and even during the pregnancy it is high likely possibility that this woman is going to struggle to be able to deal with it at a psychological level, the impact that it is going to have. And we also need to understand the kind of psychological impact that a woman has. I mean, for any woman, bearing and rearing a child is something which is so close to them emotionally. Now, in a situation like this where a woman is going through either peripartum or postpartum depression, some of the symptoms and the signs are about not being able to feel connected to the child that is there.
Right.
And the guilt, the shame, the sadness, all of those symptoms that are there that the woman is experiencing at that point in time is something that one also needs to look at, and which is where mental health rights, I mean, we are talking about so many other things over here when it comes to the act, but what about the mental health rights of an individual who's struggling with the mental health problem? And it needs to be looked at intersectionally. Just because we have one act, and of course it's a welcome act, it's something that we need, but we also need to look at mental health aspects in different medical conditions as well.
Right.
For any individual who's struggling with mental illness to be able to recognize, because over here we are talking about their ability to also decide, to choose for themselves what are their rights.
Yes.
And where there is already so much stigma when it comes to mental health.
And also, if we are talking about the rights of the unborn child, and in this case the Supreme Court has clearly given primacy to the rights of the unborn child versus that of the woman, then I think the larger question is, what is the impact of carrying through a pregnancy like that on the child that you're bringing into the world? It's not the end of the story, it's only the beginning of a new one. So I think that ignites several questions. But that brings me to my point, Dr. Amit, if you want to come back into the conversation, because if I understand this correctly, the Medical Termination of Pregnancy Act very clearly says that they will consider risk to a woman's physical and mental health. But that's again up to a certain gestational limit. That doesn't make any sense, does it?
If we see the MTP Act, basically, if we see the overall scheme and purpose, object of the Act, basically this Act is made for the mother, not the fetus. So we have to take into consideration the mother. Here the paramount consideration is mother only. So we have to see her physical and mental health both. There are several judgments which have been passed before this case, where there is no abnormality to the fetus, there is no danger to the life of the mother. Even then, the Supreme Court and various High Court have passed the order only on the ground of grave injury to the physical and mental health of the woman. So why this case was different from others? How this case, there was no difference between this case and the other one. 3 months back, on 21st of August 2023, the Honorable Supreme Court, 2-judge bench, decided to allow 27 weeks termination of pregnancy to rape survivor. After 3 months, now this is the judgment where it has been denied. And here I am 26 weeks only on the ground of merit. So I think I have been discriminated and my mental conditions have been ignored. and mental health is completely ignored in my case. And moreover, along with mental health, there are several other factors which are not being considered, like physical, financially, emotionally, socially, psychologically. All have been ignored.
So what needs to happen? I think the latter part of our conversation, we've addressed the problem, and I think all of you have brilliantly explained to us, both anecdotally and in terms of what the law says as to what the law is and what the problems with the law very apparently are. Dr. Nikhil Datar, if I can begin by asking you solutions. What do you think needs to be done immediately in order to address some of these glaring problems with the abortion laws in India?
I think first and foremost, collectively, we as a society, whether we are doctors, judges or whatever, the first thing that we need to understand that there is a big difference in the word fetus vis-a-vis word child.
Right.
Primarily, calling it as an unborn child itself is wrong. Mentally, you cannot consider it as a child. It's a fetus. And emotionally, morally, ethically and legally, if you look at the jurisprudence internationally,
yes,
then it is extremely clear that the fetus cannot have, is not supposed to have an independent right of a human being.
Right.
Unless until it is born alive on the earth. The minute it gets disconnected from the mother, it becomes an independent human being and all the rights of a human accrue to it. Up till that, it is the mother's right that prevails at all points of time. It has to be considered as an appendage, as an organ of the mother. And that is why the mother's right has to at all points of time be supreme, number one.
Right. I think which is why we asked that question at the very outset, you know, as to whose heartbeat is it anyway.
Absolutely.
I'm going to urge you to make your points very quickly because I do want to get in final comments from the other panelists as well.
Yeah. So 2-3 quick questions. If you are going to be bothered about stopping the fetal heart, then any termination, even termination done at 7 weeks of pregnancy, also ultimately means extinguishing.
Absolutely.
Of that.
So why have that difference? Professor Deepika Jain.
Third thing is that we need to understand that women who come to the court are victims of circumstances. They are not coming there to establish their rights and all that.
Absolutely.
They are people who need help. And if you don't want to help them, there is no point in discussing about this.
And like I said, only a small percentage of women actually make it to courts. The others are accessing unsafe abortions, which is why we have that glaring statistic. Professor Deepika Jain.
Yeah, so I just wanted to clarify because I don't think that clarification has come in here. The bench did not find legal grounds for termination because the law says that after 24 weeks, you cannot terminate except on 2 grounds.
Yes.
But actually, if you could have interpreted 5.1 broadly, which has been done in 2 jurisprudence in the past, where it has meant to preserve the life of the woman because there was immediate risk to a threat because of psychosis. So I think there was legal ground is what I want to establish. Otherwise, the problem is with the law, which is what Justice Chandrachud was stating in the courtroom. That's number one, which is really important to state. But the second thing, I think it's really important to understand that there is no right of the woman within this law. And we need to establish that. While there is jurisprudence that establishes it, there is no legislative understanding of that. And so the 312 and the 318 of the IPC has to go because that is what is criminalizing all of this abortion, which is provided legally by abortion service providers, and anything that falls outside will create fear of prosecution. Obviously, nobody wants to get into this.
Yes.
So that is one. And then there are conflicting legislation like POCSO, where one needs to read it harmoniously because the NCC conflicts with POCSO in terms of access to adolescent healthcare. So all of this creates a very draconian carceral framework which needs to be addressed. We cannot have a carceral framework protecting rights of pregnant persons. Obviously, this is where the problem is.
So in a certain sense, decriminalizing abortions in India is going to be a good starting point, really. Dr. Suchitra Dalvi, final comments to you.
Yeah, I completely agree that decriminalization is the way to go. And as a doctor, I would also like to say that, as a gynecologist, I, being qualified and trained and certified, provide so many more procedures which are far more, in a sense, dangerous. But I'm allowed to do so because I'm trained to do so. So there's really no need for a law to control, the interaction of providing an abortion service to a woman who needs it, no matter at what gestation age. Because conducting a cesarean section at full-term delivery definitely has higher risks. But we are allowed to do it because we are qualified.
So you're saying the gestational argument doesn't essentially make any sense?
Exactly. And the expertise of the doctor, once you're qualified, trained, certified someone, you should allow that interaction to happen the way you would say with open heart surgery or any other major surgery. It should be an interaction between the doctor and the woman herself. Bringing in many other people creates a third party, which is a violation of your human rights. in terms of your autonomy of decision making as well. So definitely decriminalization would be the way to go.
All right. Well, like I said, we've touched upon what is clearly a very sensitive issue, an issue, like I said, where if you read the letter of the law, it may seem that India is better than a lot of countries in the world that have completely, rolled back in a certain sense legal abortion. So, but in spirit, if you actually look at the law, there are so many things that still need to be addressed. We have miles to go as far as granting women the right over their own body, which, like I said, begged us to ask the question at the very outset, whose heartbeat is it anyway? We'll continue to track stories like this on We the People. Thank you very much for tuning in. Good night.